About the verdict reached today in the Kyle Rittenhouse murder trial, the not guilty on all counts. Now back to my experts, BNC's legal contributor Paul Henderson and criminal defense attorney Sue Ann Robinson. So not only have we covered the Rittenhouse trial, but we've also kept up with two other significant cases. One, the fight to save Julius Jones from execution. He's been on death row since 2002 after he was convicted of a murder that millions of people believe was committed by someone else. After years of pleading to Oklahoma's governor to follow the recommendation of his own parole board, Julius's life was saved. His sentence was commuted to life without the possibility of parole. Now, I can't help but to compare Julius's circumstances to the Rittenhouse case. Here you have a case with overwhelming evidence that points to his innocence, or at the very least, reasonable doubt as to his guilt. And even with all of that, the state of Oklahoma was ready to kill Julius. Then there's Rittenhouse, and there's no question he killed people, yet he gets acquitted. Sue Ann, is this a fair comparison?
I agree with the points that the criminal justice system has a disparate impact on people of color. I think that the fact that Julius' death penalty was commuted at the last minute is absolutely indicative of the problems with the system. Here it is that the governor is commuting his sentence saying there's some evidence or there's some issue with his actual conviction. However, he cannot apply to be pardoned, or he cannot apply for parole. We're not going to subject him to the death penalty, but we're essentially going to keep him in here, even though we know there's a possibility that there's an issue with his underlying conviction. To me, it's just, there's a problem there, because there's a next step that needs to happen, which is he should be released, right? If there's an issue with his underlying conviction, he should be retried or released.
Paul?
Okay, so here is the spectrum, and I think it's really important because you've raised it in exactly the right way. If you look and compare the Herculean effort that it took on behalf of communities of color to have the outcome for that case, and you compare it to the case that we're talking about with Rittenhouse, and the privilege, that's the issue, the privilege of white men to drift back and forth and in between vigilantism on behalf of law enforcement and self-defense on behalf of their own beliefs and fears. That's the issue, and that's exactly the conversation that we should be having in this country. Look at one end of the spectrum versus the end of the spectrum from the ruling that we just got today is entirely why we're having this conversation, and entirely why it's so important that we're advocating in this way to educate audiences so that they know where they need to advocate and how they need to advocate.
Now, the other case we're covering is the trial for Gregory McMichael, Travis McMichael, and William Bryan, the three white men charged with killing Ahmaud Arbery. Now, Paul, you mentioned on Twitter today that the Rittenhouse verdict opens up some broad interpretations about vigilantism. How so?
100%, because the vigilantism, as defined by some of these rulings, affirms how people can act on behalf of law enforcement, and that can be a dangerous thing, either by implied permission or by direct permission, especially when we have not finished the role necessary to limit or expand the reforms that we need for law enforcement in the first place, or the accountability. And remember, those are two separate things. And so when we have individuals that interpret that on their own and act with impunity, as is reflected from today's ruling, I think it's a very dangerous thing. And it's designed, if we look back from a bigger picture as to what it means for communities of color, it means that others, and specifically white people, have impunity, or they have affirmed actions, even when they include death against, again, it wasn't even black people that were shot and killed in this case, but can act with impunity as long as they carry the umbrella or the shield of vigilantism or acting on behalf of law enforcement for what they believe should be law enforcement. That's a dangerous precedent and a dangerous door to open.
Sue Ann, I got less than a minute, but I want to know, the jury in Brunswick will be deliberating next week. Do you think the reaction to the jury's verdict in Rittenhouse could have some impact?
It could have some impact in the sense that there'll be, obviously some buzz around that. But I think the jury is probably going to keep focused on what they have in front of them, which is going to be the closings pretty soon. I think one of the issues that we haven't addressed is Kyle's knowledge of the actual gun laws. We have to remember he was raised in a gun enthusiast household. And so he was sitting on the stand reciting like, oh, well, I could have a rifle, I could carry it, but I had to get somebody else to buy it for me. But I knew I couldn't do it, but I knew I could have this type of rifle, but not this one. He knew the gun laws and was discussing it while he was testifying. Just like in Ahmaud Arbery, where Travis McMichael thought he was giving all these laws and all this stuff that he learned in the Coast Guard. So they're skating on their own knowledge of the law, for sure.
All right, guys. Veteran prosecutor and BNC's legal contributor Paul Henderson and criminal defense attorney Sue Ann Robinson. Thank you guys for spending your Friday night with me. Appreciate you both.